All right, I greet you in the love and the light of the one infinite creator. We're going to continue reading from chapter 4, your rights not to be identified by the state. A driver's license is not for identification. And we're also reading chapter 5. Chapter 5, how to handle a traffic ticket. Be courteous but firm in your conviction. And I'm just going to get to it. If you guys haven't watched the first two videos, go back and watch those. Please like and subscribe. And here we go.
4. Your right not to be identified by the state. A driver license is not for identification. Most people assume, when asked for identification, that showing a state driver license or state ID is usually a safe thing to do. But not when it comes to identifying oneself to law enforcement in a traffic stop or under other circumstances where you want there to not be any ambiguity surrounding your identity as a natural man or woman. Although there are ways around this if you happen to forget, it is best to know about the importance of correctly identifying oneself to government officials, since one of their primary duties, it seems, is to assume that everyone lies within their jurisdiction, even though they know this is not true. That is, unless that assumption is properly rebutted. The first principle one must absolutely learn if they are to maintain their unalienable rights is quite simply, the government, as it is currently set up, has the legal right to absolutely control, e.g., disregarding the Constitution, anything that it creates. This is because the following documents that people accept from their government are all quasi-contracts: driver license, social security card, voter registration card, credit cards, motor vehicle certificate of title, motor vehicle registration, summons and complaints, the registration of your real estate for taxation, etc., and therefore can be adjudicated outside of the Constitution. Now, isn't that a kick in the head? You can learn more about the development of this subject in terms of its impact on the legal world in Professor Joseph Binning's 1978 book Legal Identity, The Coming Age of Public Law. In other words, your name on all of the above-mentioned documents has been converted into a legal fiction and forms what is known as a fiduciary trust in relation to the quasi-contract, which works like an adhesion contract. You might say that the driver license is similar to a waiver of rights, although the rights waived may be reclaimed at any time provided that notice is given. As briefly explained in the introduction, an adhesion contract is a standardized contract form offered to consumers of government goods and services on essentially a take-it-or-leave-it basis without affording the consumer a realistic opportunity to bargain on the terms of the contract. In other words, it is an unconscionable contract and therefore void of effect. Regarding your name, under the common law and according to the publication American Jurisprudence, use an acquisition, at common law, a person could adopt any name he or she wished, without resort to any court and without legal proceedings, provided it was not done for fraudulent purposes, and this rule is continued in some states by statute. This means you are not restricted, other than by use with fraudulent intent, with regard to any name that you wish to use to identify yourself. According to this common law principle, it is up to you to determine what your name is. In other words, it is your right to make this determination with regard to your identity. Not even the government can interfere with or force you to identify yourself by any name to which you would otherwise not recognize nor consent. When dealing with the government and its agents, in order to preserve your identity and the rights that go with it, it is best to identify yourself by your true name. What do I mean by your true name? The name your parents gave you, your first and middle names. Your true name does not include your family name. Only the first and middle names. John Stephen rather than John Stephen Smith, spelled, of course, with upper and lower case letters, and not in a stylized form in all capital letters. This way your name doesn't become confused with the legal fiction recorded by the government on their documents. It is crucial that you fully understand this principle, as it is the basis for which government contacts or has any business at all to do with you. If you know when to consent through identification, and when to withhold consent, you'll be able to avoid a lot of problems created by government in order to create a legal controversy. When government records a legal fiction name, it records that name written in all capital letters. Have you ever noticed how your name is presented on any bill that you receive in the mail, whether from the power company, the telephone company, your bank, or a government entity like the county treasurer? It's always typed in all capital letters. This is a stylized usage used by government and other corporations, fictitious entities, so that they can deal with you in the capacity of doing business as, or DBA, with another legal fiction. But just because government wants to deal with you in this manner, doesn't mean that you have to deal with it in this manner. If you allow government to construct a trust such as the driver license, with all its undisclosed terms and conditions, around your legal name, which, by the way, includes your last name, and you agree to use that legal name as your identity when dealing with government, then you've just opted into its jurisdiction and lost all your unalienable rights. It all comes down to being aware of what you are consenting to in any given situation. If you find yourself in a situation where you are asked for your license and you decide to turn it over, stop before handing it over and make it perfectly clear to the officer that I'm showing this for competency, not for identification. Make sure the officer understands what you have just done, because what you are saying is, I do not consent to being identified by this document. There have been instances where officers have gone back to their cruiser, presumably for some onboard communications with headquarters, and then returned to hand back the DL with only a warning about whatever infraction they thought they had caught. In other words, no citation, no written warning. Because you preserved your rights just by knowing how to assert them through non-consent to be identified by government documents. If you identify yourself properly, the officer will not likely proceed against a name different than that of the constructed fiduciary trust. If asked what your name is, as was just mentioned above, use only your true name, i.e. first middle, so that you can avoid making a connection with the full or legal name on the card. In order to further make this point, consider having another card made and changing your signature on your driver license to first middle. It is likely the Department of Transportation won't allow you to eliminate your last name on the printed card, but you can change the way you sign the license. Then once you have your amended card, if you ever have to give it to an officer, you can announce clearly, Officer, I am not showing you this driver license for identification purposes. I am only showing it to you to prove my competency to operate this auto, and so you know I keep a valid insurance policy active on it. I am noting your name and hope that you will recall this conversation accurately on the witness stand at trial, how I just identified myself to you. My name is clearly spelled there on the signature line. What happens when someone neglects to do this is that the court will construct a trust contract, also known as the constructive trust, in legal terminology, from your consent to be identified by the driver license. You signed the quasi-contract, license, therefore you have implied an agreement to follow the traffic code. However, even if you happen to make this mistake, there are ways to overcome it. This exception, and what you have to do in a timely manner, will be covered in more detail in a later chapter. There are things you can do to preserve your rights. Whenever you find yourself in a courtroom situation or when signing any paper or document, or instrument, such as a traffic citation, pertaining to any government or corporate agency, you can reserve your rights by signing above your signature with one or more of the following reservations. Without prejudice, or, all rights reserved, or, not amenable, or, if you are being coerced to sign under threat of jail, under protest, or, under duress. Now, this isn't a silver bullet cure-all if you don't know how to use it, however it does establish a reservation of rights, as well as a fatal error for the courts, for the natural man, as opposed to the legal fiction, who generally has no rights under natural law. It must be understood that a reservation of rights, by its declaration, or documentation, alone, vitiates perjury and will not sustain a promise or an appearance, meaning an appearance, in court. Consider the following court holding with regard to a reservation of rights. It must be permitted of men to buy their peace without prejudice to them. It has been held that one may buy his peace by compromising a claim which he knows is without right. Daly v. King 70 Mish 568, 44 NW 959. But the compromise of an illegal claim will not sustain a promise. Reed v. Hitching, 71 Me 590. According to law, liability of all parties to a contract is discharged if any party has no right of action or recourse. If remedy is not allowed in a contract, such as the quasi-contract with the driver license, then there is no actual contract at law, meaning according to the common law, that can legally be enforced. That is, unless you, ignorantly, consent to its enforcement. The court can establish in personam jurisdiction just based on the fact that you failed to rebut the assumption that you are of a class of people who are controlled by the traffic codes. However, once you rebut that assumption, you have shifted the burden of proof, and now it is incumbent upon your opponent to disprove the rebuttal through verified, sworn, evidence. This means that the officer or the prosecuting attorney has to come up with verified evidence, meaning under penalty of perjury, that positively refutes your rebuttal. The only problem with this is, if there was no injured party, they never have any such evidence. And therefore, they have no case. Another way that you waive your right to due process is by not challenging subject matter jurisdiction. One way to challenge subject matter jurisdiction is by asking for a verified complaint. The officer or prosecuting attorney is representing a corporation, a fictitious plaintiff, and bringing a claim on the presumption that a contract exists between the state and the defendant, an ignorant victim. The ignorant victim, yourself, does not know that this presumption even exists, does not know that the cause of action cannot be in the common law because a crime in law requires a corpus delicti, that is, the body of the crime. Or an injured party, and a corporation cannot be the body of the crime or an injured party because it is artificial, a fiction. Without a verified, sworn, complaint from a real, live party to the action who has sustained an injury, there is no case. What most ignorant victims aren't aware of is, the state is attempting to prosecute the suit without entering evidence into the record of the contract which binds the defendant to the law. Without such contract, and without your objecting to this on the record and insisting that an actual contract be produced and entered into evidence, the trial court is wholly in want of subject matter jurisdiction and venue jurisdiction. The court proceeds once this jurisdiction is challenged, that is, once the defendant demands to see the contract from a real party to the action. It would be proceeding without judicial immunity, therefore opening itself up to a civil lawsuit and a criminal offense under federal law. This means that the judge and everyone associated with this fraud can be sued as perpetrators to a fraud. The officer for champerty, the prosecuting attorney, if there is one, for barratry and bringing a case with unclean hands, the judge for lack of jurisdiction, and all of them for conspiracy to fraudulently conceal the true nature and cause of the accusation. Such a criminal act could even be taken to the federal courts if need be. Title 18 of the Federal United States Code at Chapter 13 Section 241, Conspiracy Against Rights, protects the public from criminal actions by public officials. Title 18 provides that everyone from the trainer of law officers to the judge to the dispatcher to the director of revenue to the law officer himself may be named as conspirators in any kidnapping, i.e., what they might call an arrest, but which is, rather, a false arrest. 18 U.S.C. Section 241, Conspiracy against rights, if two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same. Or if two or more persons go in disguise on the highway, or on the premises of another, with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined under this title or imprisoned not more than 10 years, or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping, or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, they shall be fined under this title or imprisoned for any term of years or for life, or both, or may be sentenced to death. For instance, if you were to prove the state's failure to adequately train its officers or agents concerning rights, concerning diversity of jurisdiction, etc., it could be tantamount to a conspiracy against rights in violation of Title 18 U.S.C. Section 241. If your state driver license was done with a reservation of rights, making clear that there was no intent to become a fiduciary trust for John S. Smith, that any attempt on the government actor's part to bypass the refusal for cause or the reservation of rights would be deemed a conspiracy against rights per Title 18 U.S.C. Section 241. 5. How to handle a traffic stop. Be courteous but firm in your conviction. Being pulled over to the side of the roadway by a law enforcement officer, Leo, can be an anxiety-ridden event. However, if you have done nothing wrong and you know your rights and how to assert them, there's no need to become overly anxious. Relax and be courteous. Yet, recognize that you are potentially being pursued by a revenue agent for a municipal or corporate state government, and that this agent has certain limitations to the authority he wields, of which he must be always mindful. Reminding him of those limitations from time to time during your encounter with him will be one of the things you will want to accomplish in order to inform him that you know your rights and that you expect them to be honored. When a police officer stops you on the street, the law says that the stop will fall into one of three categories: consensual contact, detention, and/or arrest. In the event that you are stopped for a traffic issue, the officer will likely attempt to engage you in the first, and the encounter may never proceed beyond that point. How you handle this encounter at the very outset will determine which, if any, of these three categories your stop falls into, and depends on how clearly you understand your right to limit contact with government and its agents. It is up to you to question and to make a determination of the authority of anyone who approaches you purporting to represent a government agency. If you can establish a courteous beginning, with respect shown by both sides, you're likely to obtain the outcome you want. But be aware that the Leo wants to build a case against you for some traffic infraction, and that he needs your consent in order to do that. Remember, anything you say, or documents you provide, can and will be used against you in a court of law. If the stop has nothing to do with an actual crime and you can establish that fact at the outset of the contact, you can then put the officer on good faith notice that you do not voluntarily consent to being detained and then pose to him your own questions. The reason for doing this is, if you do not personally establish by your own statement that you do not agree to be stopped, then you are said to allow a presumption to be created, under the law, that you do agree to being detained. One thing to be aware of is that once you are stopped, you have the right to be allowed to go on your way within a reasonable time limit. Once that time limit has been reached and the attending officer has not established reasonable cause for the stop, you are within your rights to be free to go, and there is nothing that the officer can lawfully do to stop you. That time limit as established in statutory law is 15 minutes. In other words, if you inform the officer at the outset that he has 15 minutes, starting now, to establish his reasonable cause for the stop, and that if that fact has not been established, then you will be on your way without any hindrance. This immediately puts the officer on the spot, and puts a time clock on his actions. It also informs the officer that you understand your rights under the circumstances, and that you intend to assert them. There are several ways to handle these encounters. The way you choose will likely depend on how comfortable you are proceeding down that road, and whether or not you are aware of how to defeat any citation that may be issued. Until you become more aware of your rights in these situations and can get over the intimidation factor of having to deal with what is essentially an armed thug, you may just cooperate and get the ordeal over with. If the worst that happens is that you are issued a citation, that is the least of your problems, and can be dealt with in a highly effective manner, which will be explained in the next chapter of this book. However, if you are ready to stand your ground and to test this officer's professionalism and integrity, you may consider proceeding according to the outline below. You will want to be certain to make clear, concise statements and to use closed-ended questions that can be answered with a yes or no. Remember, the first objective of the officer in dealing with you is to form a contract, such as, "May I see your driver's license and registration?" Or, "Will you please roll down your window a little further?" If you immediately comply with either of these requests without questioning it or without objecting to it, it is deemed, in law, an oral contract. In other words, you have just consented to the contact. Remember the first category above. Consensual contact. Just be aware that you have the right to ask the officer for his identification also, in the form of his business card, which he is by law supposed to carry on his person at all times, in order to satisfy yourself that he isn't an imposter. Or that you can object to the contact by stating that you do not consent to this contact, at the very outset of the encounter. Remember, under the Constitution you have a right to remain silent, Fifth Amendment, and to not interact with government actors. If you intend to interact with the officer, then the following 5 questions and statement are really all that is needed to control most police encounters. They may seem somewhat counterintuitive at first glance, until you realize that by consenting to the contact, you waive your right to remain silent. It is almost never a good idea to converse with law enforcement, especially when you are being stopped in a traffic issue. These questions are simple and will generally solicit a predictable and reliable response. The first 4 questions are designed to demonstrate knowledge of your rights to the officer, that unless he has specific and articulable facts to detain you or a warrant, you should be free. What is the nature of your inquiry? Let him state his cause. If he asks you for your driver license and registration, you should reply. 2. Is that a request or a demand? Let him answer one way or the other. Once he has follow up with the third question, you should know that you are within your rights to deny a request, but can only accede to a demand, under duress. Make sure you say something like, "I am handing this over under duress," to get it on the record. 3. Do I have the right to remain silent? This lets him know that you want him to respect your rights. If he becomes belligerent about the matter, calmly follow up with questions 5 and 6. Once he agrees to recognize your rights, ask the 4th question. 4. Am I free to go? 5. Can anything I say to you or any documents I give to you be used against me in any legal matter? You and he both know that this is true. 6. I am not refusing to cooperate. I am exercising my right to remain silent. By making this statement, you are exercising your right to remain silent. If you get as far as the fourth question and the officer is still attempting to detain you, then this stop and detention becomes a Fourth Amendment issue. Unless you have committed a known crime according to common law and common sense that the officer has witnessed, then your Fourth Amendment rights against unwarranted search and seizure apply and you cannot be forced to produce anything. In a second scenario, rather than ask, "What is the nature of your inquiry?" you can state right at the outset that, "Before we go any further, I do not consent to this contact, and I reserve all my rights. I accept your oath of office as binding." Accepting their oath of office puts them on notice that they must abide by their constitutional oath and uphold your rights. If they do not, they can be held personally liable for any injury they may cause you. You can even tell them this. After stating that you do not agree to being stopped and detained for no articulable reason, you must ask the officer if he is detaining you. If the officer answers he is not detaining you, then you inform him that you will be on your way. If the officer answers that he is detaining you, then you must ask the officer, does he have a well-founded probable cause? Specific and articulable facts is the phrase that officers are taught and use to describe this, that you have committed a crime known to the people's common law as his basis for detaining you, and that you expect a good faith answer from him. If the officer states he has no such well-founded probable cause, then you inform him that you will be on your way. It will be helpful, at this point, for you to remind him that when an individual is detained, without warrant and without having committed a crime, traffic infractions are not crimes, the detention is a false arrest and unlawful imprisonment. If the officer goes silent, continue to ask, "Am I free to go?" until you receive a yes. If the officer states that he does have a well-founded probable cause, it had better be connected to your committing some felony crime against a person who has entered a complaint or a breach of the peace known to the common law of which he has personal knowledge. If his probable cause proves to be merely connected with the state's traffic regulatory law scheme, which includes any local traffic regulatory ordinance or code, then he is violating your sovereign right to life, liberty and property. And by his detaining you he is holding you under false arrest and false imprisonment pursuant to the common law. With regard to whatever probable cause or probable suspicion he may come up with, ask him if he has a license to make such a legal determination. If he answers yes, ask to see his license. If he has one, this means he must be some sort of attorney in addition to being a law enforcement officer. If he does not have an attorney's license, he is not legally competent or licensed to make a legal determination, and therefore must allow you to be on your way. If a demand is made, ask the question, "Can anything I say to you or any documents I give to you be used against me in any legal matter?" This is a dilemma for the officer. They are supposed to take an oath which binds them to the Constitution. Their oath to abide by the Constitution takes precedence over any request or demand for information they may make. They may choose to repeat their demand, and possibly become uncivil. Just keep asking the question until you receive an answer. If you are not willing to stay the course because you feel that the officer may become violent, you can say, "Since you are using color, pretense, of law, threatening me with bodily harm, and forcing me to do business with you against my will, I am happy to cooperate under duress. May I please have your business card?" Then give them what they are requesting. If you have a driver license, make certain to state that it is not for identification purposes. Remember to give your identity as true name, first middle, only. You do not want to create a nexus between the artificial person, the legal fiction, and your status as a natural man or woman. Make a mental note of what they say to you and write out a report of the facts of the incident as soon as possible to be used in an affidavit in case you want to file a tort claim against them later. Make a mental note of what they say to you and write out a report of the facts of the incident as soon as possible to be used in an affidavit in case you want to file a tort claim against them later. If they refuse to give you their card, memorize their badge number and/or name. In point of fact, refusing to supply you with their business card is an infraction of their duty and a cause of action in a civil suit. Then again, if at the time you are stopped you really are a party subject to the administrative law or ordinance he thinks you have violated, which means that you must be employed in using the roadway for profit or gain, then his probable cause may have a legal basis. But unless you are stopped while driving a school bus or are a state employee or are engaged in commercial activity, like transporting cargo or persons for pay, the odds are slim indeed that you are subject to your state's traffic regulatory scheme. Know that there are constitutional grounds which will defeat a traffic law violation charge no matter the circumstances. If the officer should detain you without stating any probable cause reason after your proper good faith demand for one or can only claim some administrative law violation without being able to show his probable cause grounds or evidence, like a quasi-contractual agreement based on your having and identifying yourself with a driver license, of why he thinks you are subject to it, then he is proceeding under color of office. If you haven't shown him a DL and he starts asking for one, then he is fishing for evidence, and that too is a no-no, Fourth Amendment violation. Under the Fourth Amendment, you have the right to be secure in your person, papers and property from unreasonable searches and seizures without a proper warrant being presented. He is using color of process. This means he is proceeding under color of law. At this point, it might be beneficial to warn him that tort damages and civil rights violation damages are in the making should he continue with this line of pursuit. Always keep in mind that the officer will do whatever he believes he can do. If he becomes aware that you know your rights under this situation and that he can personally be held liable, that may be enough to make him pause and reconsider his course of action. Of course, it is always possible that an officer may have just cause for stopping you. For example, if you are proceeding the wrong way down a one-way street, or the like. You have a duty and an obligation to observe the customs and rules of the road. In the case of any kind of unjustified detention, just remember the following. It must be recognized that whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person. Terry v. Ohio, 392 U.S. 1, 16, 1968. Also be aware that an illegal arrest is an assault and battery. State v. Robinson 145 Me 77, 72 ATL 2D 260, 262, 1950. So, the officer faces these possible circumstances should he proceed with an actual arrest without probable cause. Of course, you must understand that the officer may actually believe he has probable cause because he has observed prima facie evidence that you are within his jurisdiction and that you have violated a regulation or statute within that jurisdiction. If after the above-mentioned events, where you are being forced to do business with the officer, you are asked to sign anything, like a citation, put the words, under duress, above your signature. This preserves your common law rights when brought out in court proceedings, even if you have been forced to turn over a driver license and registration. What matters in court is that you were not engaged in any regulated activity, commerce for hire, at the time of the stop. What is important to establish from the very outset of the traffic stop event is your refusal to do business with the officer, if, indeed, you have committed no offense. Once you've been able to determine his reason for stopping you, you are perfectly within your rights to tell him, "I do not consent to this conversation." Always respond to any request for information or documents with the question, "Is that a request or a demand?" If it is a request, ask, "Do I have the right to remain silent?" To which he should answer, "Yes." Then you follow that by asking, "Am I free to go?" Your encounter can be this short if you stay focused, and no demands are made. Asking, "Am I free to leave?" is important in establishing that you do not consent to this contact. Ask this several times to make sure the cop will have a hard time denying this and saying you didn't mention it later on if you get to court. If it is really a consensual contact, the officer ought to let you go on your way if you ask to go. If you don't actually verbally ask to leave, the court will presume that you consented to whatever follows.
All right, that's it. We're going to pick up next time, Chapter 6, what to do if you are cited, how to handle this matter administratively. So until next time, don't forget to like and subscribe.